All right, so we're discussing goods. We're discussing contracts that include sales of goods along with something else, right? So there are two situations where this normally arises, right? The contracts that include goods attached to real estate, right? Or a contract for a goods and services combined, right? So, how to tell whether the UCC applies. For real estate, we're going to look to the UCC 2-107. And in general, a sale of goods from real estate will be a contract for goods covered by the UCC under certain conditions, right? So, in the case where we're talking about minerals or oil, natural gas, things like that, gold, iron, right? If severance is going to be made by the seller, then UCC applies. If severance is going to be made by the buyer, then that's basically a sale of real estate along with the mineral rights pertinent to that real estate, right? But if severance is going to be made by the seller, then the UCC is going to apply to the sale of goods. Severance is the act of separating the goods from the land, right? Of mining the ore, of putting the oil in the oil well, right? Pumping the oil out of the oil well. So if that severance is made by the seller, then it's going to apply. In the case where we're selling crops that are growing, right, or timber that's going to be cut, right, the severance is going to be irrelevant, regardless of who is going to make severance. The sale is a sale of goods. So if I go to, for example, an apple farm and I pay them $50 to pick my own apples, right? Then I come up with a few bushels of apples and I've made severance myself. I picked them myself. But that sale under UCC 2-107 will in fact be a UCC covered sale. Now on to the second situation where goods and services may be combined, right, as opposed to goods and real estate. The courts have come up with what is known as the predominant factor test. Again, that's the predominant factor test. And what this will seek to do is to determine what is the most important, most significant, the most salient part of that contract. And if it determines that goods predominate, then the UCC is going to apply to the entire contract, not just the goods portion, but also the services portion. If services are determined to predominate, there will be no UCC reading of that contract. It will be read under the common law of contracts and under any other statutory provision, but it won't be a UCC covered contract. So under your case example 19.2 is a good example of this. SAC versus Cessna Aircrafts. So a company buys a jet from Cessna Aircraft Company in order to help recoup some of the cost of acquiring this jet. They enter into, within the same contract, a services contract whereby Cessna would manage that jet, rent out its idle time in order to help them recoup some of that cost, right? A couple of years down the road, Cessna cancels the services portion of that contract, right? And the company has to sell that jet for less than 80% of what they paid for it, so they feel they have damages. They sue, and the lower court determines that the UCC doesn't apply, so this can't be a UCC suit. They toss it out, right? The appellate court went the other way. They said that the clear purpose of the contract, despite the fact that these services are provided, and despite the fact that the contracting parties were attempting to recoup some of this cost by having the services contract, the clear overriding predominant factor that applies to this contract is the fact that they wanted to acquire the jet, right? And so the UCC should apply to the entire thing, not just to the sale of the jet itself. And this is the case despite of the fact that the contract involves a sale of goods, the jet, and the distinct sale of a very significant service. All right, it's still ruled that the predominant factor was the fact that the goal was to actually acquire the jet. A few other things. All right, so who is a merchant? The status of being a merchant is important under the Uniform Commercial Code because some provisions specifically are related to how merchants behave, right? What a merchant is permitted to do, what a merchant is required to do, and what is expected of a merchant in a commercial sales or lease agreement. So what is a merchant? This is covered under the Uniform Commercial Code 2-104. Has the three ways in which a person can be a merchant. I'll go over them very briefly, all right? They deal in goods of the kind at issue in the contract. 1, they deal in goods of the kind at issue in the contract, right? 2, or, right, number 2, they hold themselves out by occupation as a person with special knowledge or skill related to the practices or goods in the contract. All right, so 2, by their occupation, they hold themselves out as having special knowledge or skill related to the goods subject to the contract. 3rd, all right, if you employ a broker, agent, or other intermediary who is a merchant, that transaction, right, as it relates to you, will encompass you as the merchant, right? So if I get a broker to sell my car or my boat, right, that transaction, because I've used a broker, even though I'm not a merchant of boats, right, that transaction will be covered under the UCC as if I were a merchant, right? Why does that matter? You'll see as we kind of roll along, there are some places where merchants have a special status and they have special requirements, or they have additional factors that are sort of attached to them, all right? Now, let's talk briefly about leases. Where a sale is the passing of title from the seller to the buyer for a price, a lease involves a lessor, right, permitting a lessee to have exclusive use and enjoyment of a good for a period of time in exchange for a price, right? So a lease transfers the right to possess and use goods for a period of time in exchange for a payment. This is covered under Article 2A of the Uniform Commercial Code, and its provisions generally run parallel to those of Article 2, which covers sales. Article 2A covers any transaction that creates a lease as opposed to a sale contract. And it applies to any transaction that creates a sublease. A sublease is when a party with the leasehold interest, right, they, again, lease that property to another party who wasn't originally in that contract, all right? Article 2A is basically a repetition of Article 2. It applies to leases instead of sales. There are some differences. I'm not going to make a huge deal out of them. I think I'll focus more on their similarities because that is the most important thing that I need you to walk away from this with. So a lease agreement, definitions will be found in 2A 102 as opposed to Article 2. Article 2A 102, 2A 103. A lease agreement is a bargain between a lessor, that's the party who is equivalent to the seller in a sales agreement, and a lessee for the lessee to acquire the right to possess and use those goods. Here we should note that Article 2A applies to all types of leases of goods, whether they be commercial leases of goods or consumer leases of goods. We should note that 2A does have special provisions that relate specifically to consumer goods, and there may be different ways that that consumer leases may be treated somewhat differently from commercial leases. A consumer lease has three elements, right? One, a lessor who regularly engages in leasing or selling, basically a merchant. A lessee who leases the goods for personal, family, or household purposes, otherwise known as non-business purposes. And number three, total lease payments are less than the dollar amount set by the statute in that state, say $30,000 or $50,000, right? These consumer leases have special protections because they involve, individual consumers. And so certain provisions of 2A apply only to consumer leases. For example, one provision states that a consumer may recover attorney's fees if a court finds that a term in a consumer lease is unconscionable. You may recall unconscionability as being one of the defenses to contract enforcement from Business Law 1. It's just an example, but an unconscionable contract provision is one that is so one-sided and abusive that courts just say we're going to abrogate your freedom of contract. We're not going to allow the party to even agree to that. All right. And so all of that is by way of very significant and important background for what we're actually going to be talking about in this chapter, and that is the formation of sales and lease contracts, right? So we've discussed what a sale is. We're going to come back to sales. We're going to come back to leases. We're going to come back to title, especially in the next chapter. But first, we're going to go back to those bread and butter concepts that we used to understand contracts in the first place. Offer, acceptance, consideration, capacity, and legality. If you'll remember, these are the elements of a proper, legally enforceable contract. Offer, acceptance, consideration, capacity, and legality. We learned in Business Law 1 that in order for an offer, let's start with the offer, right? The offer is the expression of a willingness to be bound on the part of the party making the offer, known as the offeror, right? And so we know that in order for that offeror to be bound, we have to have an unmitigated, unqualified acceptance on the part of the offeree. In commercial transactions, right, there may be a lot of back and forth, and it may be less determinable as to when, at what point, a contract was formed. So what does this mean? The UCC actually has provisions that state that an agreement may be formed, right? An agreement sufficient to constitute a contract can exist even if the moment of its making is not yet determined. That is UCC 2-204 sub 2, 2-204 sub 2, and 2A-204 sub 2 for sales and leases each. Why would that be, you may ask? Why would we have a different rule in this context? It's the speed of commerce, essentially, right? So there are a number of things that have to attach to an offer, right? For example, in addition to expressing an unequivocal willingness to be bound, I, as the offeror, have to express reasonably certain terms so the other party can know what they're agreeing to, right? We're not under the UCC. Under the UCC, there may be it may not be as crucial that there be reasonably certain terms. That's an interesting, if you remember this concept, right? It's an interesting wrinkle. At common law, there have to be reasonably certain terms, reasonably definite terms, for a court to be able to attach a remedy to a contract. And if there are not, then that contract is going to fail for lack of definiteness, right? Under the UCC 2-204, there are a couple of, there is some flexibility to this common law concept, all right? If the parties intended to make a contract, all right, and remember, we go back to our objective theory of contracts in order to determine whether the parties intended to make a contract, right? But if the parties intended to make a contract and there's a reasonably certain basis for the court to grant an appropriate remedy to the parties seeking relief, then a contract will be found. As simple as that. Other than UCC 2-204 and 2A-204, which have this general sort of permissiveness for open terms, there are a number of other provisions within the UCC that specifically relate to the types of open terms that might be left open. However, you should keep in mind that this original requirements from 2-204 and 2A-204 still apply, which means that if too many of the terms are left open, then it's possible that the court won't determine that the parties intended to make an actual contract. And of course, if the parties did not intend to make an actual contract as determined by the court, there is no contract, right? Or they may determine that there just isn't enough of a basis for them to grant relief, right? So there is a certain amount of uncertainty that might be created by by open terms within a contract. But in general, we have specific provisions that help us deal with each of these different types of open terms. So let us begin with an open price term. If the parties don't agree to a price, right, but they still behave as if there's a contract, then a court can simply fix a price, a reasonable price at the time of delivery. That's UCC 2-305, all right? If either the buyer or the seller can fix the price, they must do so in good faith. Good faith is honesty in fact and the observance of reasonable commercial standards of fair dealing and trade. Good faith is defined in UCC 2-103 sub 1B, all right? So then there's the case where the price fails to be set through the fault of one of the parties who didn't take appropriate action. In this situation, the other party can treat the contract as canceled, or they can simply use their good faith and pick a reasonable price and simply pay. All right, that sounds a little odd, but it's sort of like a last case scenario in order to prevent the absolute failure of a contract and also to narrow the issues that have to get resolved in case that is regarded as a breach by the other party. So in example 19.3, Perez and Merrick enter into a contract for the sale of unfinished doors and agree that Perez will determine the price. Perez refuses to specify the price. Merrick can treat the contract as canceled, or he can simply set a reasonable price per door using good faith as defined under UCC 2-103. After open payment terms, we should also consider the possibility after open price terms, we should also consider the possibility of open payment terms. If they don't specify when payment is to be made, payment is due at the time and the place where the buyer is to receive the goods under UCC 2-310 sub A. The buyer can tender payment using any commercially normal or acceptable means, such as check or a credit card. If the seller demands payment in cash, the buyer has to be given a reasonable time to obtain the cash. That's again UCC 2-511 sub 2, all right? So we've done open price term, open payment term. What about open delivery terms? Generally speaking, if there is no delivery point specified in the contract, then the buyer takes delivery at the seller's place of business under the UCC 2-208. If the seller has no place of business, then the seller's residence becomes the seller's place of business under UCC 2-308. If the time for shipment or delivery is not clearly specified in the sales contract, the court will infer a reasonable time for performance, 2-309 sub 1. That's all going to depend on facts and circumstances, right? So, for example, if I buy a piece of art, right, from a private collector, right, and I give him the cash, I send him the cash electronically, right? He's to deliver it. If it's delivered within a few weeks, that seems fairly reasonable, right? If it's not delivered for 8 months, we may have a dispute and a court may determine that that's not reasonable, right? Next, open duration terms. What happens if there's an open duration? So the parties have a series of successive performances and there is no specification as to whether this is a 1-year contract or a 5-year contract. The law makes this type of contract terminable at will under UCC 2-309 sub 2 and sub 3. All right. So this type of contract is terminable at will. However, reasonable notification must be given to the other party based on the course of dealing between those two parties. All right. But if the duration is open, that doesn't cause the contract to fail. It simply makes that contract terminable at will. So this brings us to open quantity terms. A contract that does not specify a quantity of goods would normally not be a good contract, right? There is no way for a court to determine a remedy if there is no objective knowledge on the court's part of what a reasonable quantity would be. There's almost no way for a court to determine that. Nevertheless, the UCC does recognize a couple of types of contracts in which an open quantity term is both permissible and which it will find enforceable, right? So there are requirements contracts and output contracts. So a requirements contract is a type of contract where, let's say that I'm a merchant and I sell a certain amount. Let's say it's a restaurant and I sell ice cream, right? And I know I need X amount of ice cream, right? But I can get a better deal if I buy all of my ice cream from Ben & Jerry's, right? As opposed to having 5 different sources for ice cream. So I enter into a contract, and in exchange for this favorable rate, I buy all of my ice cream from Ben & Jerry's. So in that case, the buyer agrees to purchase and the seller agrees to sell all or up to a stated amount of what the buyer needs for their business. All right. So in this case, there is an implicit consideration of the fact that this business has a pattern, right? And the expectation would be that the pattern would not be deviated from one period to another very substantially, right? So if I bought X number of gallons in 1 year, right, then the amount might not be the same in the following year, but if it's drastically different, right, either up or down, right, that would suggest that there's a breach in that contract, or that the other party might not be required to fulfill that requirement. All right. If a buyer promises to purchase only if the buyer wishes to do so, the promise is an illusory contract, and that's not a requirements contract, right? So it has to be an actual requirements contract. The other is for output contracts. So let's say I manufacture ice cream, and my ice cream is very special, right? And this company wants to be my exclusive agent with regard to selling my ice cream, right? Then it would buy all of my output, all right? And again, I can't quadruple my output in a year and think that that would be covered by that contract. But the seller agrees to sell and the buyer agrees to buy all or up to a stated amount of the output of that business. So example 19.7, Ruth Sewell planted 2 acres of organic tomatoes. Bella Union, a local restaurant, agrees to buy all of the tomatoes that Sewell produces that year to use in their restaurant. Again, because the seller essentially forfeits the right to engage in sales with anyone else, right? There is implicit consideration for that original contract. And this is, of course, bounded by a good faith limitation on requirements and output contracts. The quantity under such contracts is the amount of requirements of the amount of output that occurs during a normal production year. The actual quantity purchased or sold cannot be unreasonably disproportionate or incomparable to prior years under that contract. Here's another point on offers before we move on to acceptances, and that is something you may have learned briefly about in Business Law 1, and that is the merchant's firm offer, otherwise known as a possible exception to the fact that advertisements are never offers, right? If you recall from Business Law 1, advertisements are not offers, but they are in fact invitations to deal, pre-negotiation type instruments, right? The exception to that are merchants' firm offers. So under a regular contract principle, an offer can be revoked at any time for any reason prior to acceptance. This is not true with regard to a merchant's firm offer. A merchant's firm offer is a writing signed by a merchant that promises to hold a deal open for a certain period of time. And this is codified under UCC 2-205, also for leases under 2A-205, right? So in the book's example 19.8, Osaka, a used car dealership, emails Salcedo on January 1 stating, I have a used 2018 Toyota RAV4 on the lot that I'll sell you for $26,000 anytime between now and January 31st. All right. This email creates a firm offer, and Osaka will be liable for breach if he sells that Toyota RAV4 to someone other than Salcedo before January 31st, because he says he'll hold it open. All right. The caveat is that a merchant's firm offer under the UCC 2-205 and 2A-205 cannot exceed a reasonable period beyond any period at all beyond 3 months, right? It'll be held open for the stated period up to 3 months or for a reasonable period, all right? So the next topic that we'll address is acceptance.